Okay, we're up to episode 10, streaming through the Mueller report audiobook. We're now moving towards the end of volume 1, and following is about 20 pages of prosecution decisions. So I expect this to be fairly dry, so bear with me or use this to help your sleep. Okay, we're up to page 174. Prosecution and declination decisions. The appointment order authorised the Special Counsel's Office to prosecute federal crimes arising from its investigation of the matters assigned to it. In deciding whether to exercise this prosecutorial authority, the Office has been guided by the principles of federal prosecution set forth in the Justice, former US Attorneys, Manual. In particular, the Office has evaluated whether the conduct of the individuals considered for prosecution constituted a federal offence and whether admissible evidence would probably be sufficient to obtain and sustain a conviction for such an offence. Justice Manual 927, where the answer to those questions was yes, the Office further considered whether the prosecution would serve a substantial federal interest. The individuals were subject to effective prosecution in another jurisdiction, and there existed an adequate non-criminal alternative to prosecution. As explained below, those considerations led the Office to seek charges against two sets of Russian nationals for their roles in perpetrating the Active Measures social media campaign and computer intrusion operations. And we've got a redaction there. The Office similarly determined that the contacts between campaign officials and Russia-linked individuals either did not involve the commission of a federal crime or, in the case of campaign finance offences, that our evidence was not sufficient to obtain and sustain a criminal conviction. At the same time, the Office concluded that the principles of federal prosecution supported charging certain individuals connected to the campaign with making false statements or otherwise obstructing this investigation or parallel congressional investigations. Russian Active Measures social media campaign. On February 16, 2018, a federal grand jury in the District of Columbia returned an indictment charging 13 Russian nationals and 3 Russian entities, including the Internet Research Agency, IRA, Concord Management and Consulting, LLC, Concord, with violating US criminal laws in order to interfere with the US elections and political processes. The indictment charges all of the defendants with conspiracy to defraud the United States, count 1, 3 defendants with conspiracy to commit wire fraud and bank fraud, count 2, and 5 defendants with aggravated identity theft, counts 3 through to 8. Internet Research Agency indictment. Concord, which is one of the entities charged in the Count 1 conspiracy, entered an appearance through US counsel and moved to dismiss the charge on multiple grounds. In orders and memorandum opinions issued on August 13 and November 15, 2018, the District Court denied Concord's motions to dismiss. As of this writing, the prosecution of Concord remains ongoing before the US District Court for the District of Columbia. The other defendants remain at large. Although members of the IRA had contact with individuals affiliated with the Trump campaign, the indictment does not charge any Trump campaign official or any other US person with participating in the conspiracy. This is because the investigation did not identify evidence that any US person who coordinated or communicated with the IRA knew that he or she was speaking with Russian nationals engaged in the criminal conspiracy. The Office therefore determined that such persons did not have the knowledge or criminal purpose required to charge them in the conspiracy to defraud the United States, count 1, or in the separate count alleging a wire and bank fraud conspiracy involving the IRA and 2 individual Russian nationals, count 2. The Office did, however, charge 1 US national for his role in supplying false or stolen bank account numbers that allowed the IRA conspirators to access US online payment systems by circumventing those systems' security features. On August 12, 2018, Richard Pinedo pleaded guilty pursuant to a single count information to identity fraud in violation USC 1028. Plea agreement identifying numbers there. The investigation did not establish that Pinedo was aware of the identity of the IRA members who purchased bank account numbers from him. Pinedo's sales of account numbers enabled the IRA members to anonymously access a financial network through which they transacted with US persons and companies. On October 10, 2018, Pinedo was sentenced to 6 months of imprisonment, to be followed by 6 months of home confinement, and was ordered to complete 100 hours of community service. Russian hacking and dumping operations. Section 1030, Computer Intrusion Conspiracy. On July 13, 2018, a federal grand jury in the District of Columbia returned an indictment charging Russian military intelligence officers from the GRU with conspiring to hack into various US computers used by the Clinton campaign, DNC, DCCC and other US persons in violation of 18 USC numbers there, committing identity theft and conspiring to commit money laundering in furtherance of that hacking conspiracy in violation of 18 USC 1028 and 1956 counts 2 through 10, and a separate conspiracy to hack into the computers of US persons and entities responsible for the administration of the 2016 US election in violation of 18 USC 1030-371 count 11. Netishko indictment. As of this writing, all 12 defendants remain at large. The Netishko indictment alleges that the defendants conspire with one another and with others to hack into the computers of US persons and entities involved in the 2016 US presidential election, steal documents from those computers, and stage releases of the stolen documents to interfere in the election. Netishko indictment number 2. The indictment also describes how, in staging the releases, the defendants used the Gustavor 2.0 persona to disseminate documents through WikiLeaks. On July 22, 2016, WikiLeaks released over 20,000 emails and other documents that the hacking conspirators had stolen from the DNC. Netishko indictment number 48. In addition, on October 7, 2016, WikiLeaks began releasing emails that some conspirators had stolen from Clinton campaign chairman John Podesta after a successful spearphishing operation. Got significant redactions there for the rest of that page, and another full page of redaction, page 177, redaction harm to ongoing matters, so it's in reference to ongoing matters. Page 178 is also fully redacted. Page 179, potential violation by redaction, name kept private, personal privacy. So see United States versus Willis. Reflect Congress's desire to reach intentional acts of unauthorized access rather than mistaken, inadvertent or careless ones. In addition, the computer redaction likely qualifies as a protected one under the statute, which reaches effectively all computers with internet access. Redaction. Applying the principles of federal prosecution, however, the office determined that prosecution of this potential violation was not warranted. Those principles instruct prosecutors to consider, among other things, the nature and seriousness of the offence, the person's culpability in connection with the offence, and the probable sentence to be imposed if the prosecution is successful. Russian government outreach and contacts. As explained in Section 4 above, the officer's investigation uncovered evidence of numerous links, i.e. contacts, between Trump campaign officials and individuals having or claiming to have ties to the Russian government. The office evaluated the contacts under several sets of federal laws, including conspiracy laws and statutes governing foreign agents who operate in the United States. After considering the available evidence, the office did not pursue charges under these statutes against any individuals discussed in Section 4 above, with the exception of FARA charges against Paul Manafort and Richard Gates based on their activities on behalf of Ukraine. One of the interactions between the Trump campaign and Russia-affiliated individuals, the June 9, 2016 meeting between high-ranking campaign officials and Russians promising derogatory information on Hillary Clinton, implicates an additional body of law, the campaign finance statutes. Schemes involving the solicitation or receipt of assistance from foreign sources raised difficult statutory and constitutional questions. As explained below, the Office evaluated those questions in connection with the June 9 meeting, and then a redaction, possibly on the Office's final view on it. The Office ultimately concluded that, even if the principal legal questions were resolved favourably to the government, a prosecution would encounter difficulties proving that campaign officials or individuals connected to the campaign willfully violated the law. Finally, although the evidence of contacts between campaign officials and Russia-affiliated individuals may not have been sufficient to establish or sustain criminal charges, several US persons connected to the campaign made false statements about those contacts and took other steps to obstruct the Office's investigation and those of Congress. This Office has therefore charged some of those individuals with making false statements and obstructing justice. Potential coordination, conspiracy and collusion. As an initial matter, this Office evaluated potentially criminal conduct that involved the collective action of multiple individuals, not under the rubric of collusion, but through the lens of conspiracy law. In so doing, the Office recognised the word collude appears in the Acting Attorney General's August 2, 2017 memorandum. It has frequently been invoked in public reporting, and it is sometimes referenced in antitrust law. But collusion is not a specific offence or theory of liability found in the US Code, nor is it a term of art in federal criminal law. To the contrary, even as defined in legal dictionaries, collusion is largely synonymous with conspiracy, as that crime is set forth in the General Federal Conspiracy Statute. Collusion is an agreement to defraud another or to do or obtain something forbidden by law. Alexander Burrell Law Dictionary Glossary, 1871. An agreement between two or more persons to defraud another by the forms of law or to employ such forms as means of accomplishing some unlawful object. Bovier's Law Dictionary, 1897. Not sure whether that's referring to... so the first one was from Burrell, 1871. Bovier's Law Dictionary from 1897 says, an agreement between two or more persons to defraud a person of his rights by the forms of law to obtain an object forbidden by law. For that reason, this Office's focus in resolving the question of joint criminal liability was on conspiracy as defined in federal law, not the commonly discussed term collusion. The Office considered in particular whether contacts between Trump campaign officials and Russia-linked individuals could trigger liability for the crime of conspiracy, either under statutes that have their own conspiracy language or under the General Conspiracy Statute. The investigation did not establish that the contacts described in Volume 1, Section 4 amounted to an agreement to commit any substantive violation of federal criminal law, including foreign influence and campaign finance laws, both of which are discussed further below. The Office therefore did not charge any individual associated with the Trump campaign with conspiracy to commit a federal offence arising from Russia contacts, either under a specific statute or under Section 371's Offences Clause. The Office also did not charge any campaign official or associate with a conspiracy under Section 371's Defraud Clause. That clause criminalises participating in an agreement to obstruct a lawful function of the US government or its agencies through deceit or dishonest means. The investigation did not establish any agreement among campaign officials or between such officials and Russia-linked individuals to interfere with or obstruct a lawful function of a government agency during the campaign or transition period. And as discussed in Volume 1, the investigation did not identify evidence that any campaign official or associate knowingly and intentionally participated in the conspiracy to defraud that the Office charged, namely the active measures conspiracy described in Volume 1, Section 2. Accordingly, the Office did not charge any campaign associate or other US person with conspiracy to defraud the United States based on the Russia-related contacts described in Section 4 above. Potential coordination. Foreign agent statutes. The Office next assessed the potential liability of campaign-affiliated individuals under the federal statutes regulating actions on behalf of or work done for a foreign government. Governing law under 18 U.S.C. 951, it is generally illegal to act in the United States as an agent of a foreign government without providing notice to the Attorney General. Although the defendant must act on behalf of a foreign government as opposed to other kinds of foreign entities, the acts need not involve espionage. Rather, acts of any type suffice for liability. An agent of a foreign government is an individual who agrees to operate in the United States subject to the direction or control of a foreign government or official. The crime defined by Section 951 is complete upon knowingly acting in the United States as an unregistered foreign government agent. The statute does not require willfulness, and knowledge of the notification requirement is not an element of the offence. The Foreign Agents Registration Act, FARA, FARA, generally makes it illegal to act as an agent of a foreign principal by engaging in certain, largely political activities in the United States without registering with the Attorney General. The triggering agency relationship must be with the foreign principal or a person any of whose activities are directly or indirectly supervised, directed, controlled, financed or subsidised in whole or in a major part by a foreign principal. That includes a foreign government or political party and various foreign individuals and entities. A covered relationship exists if a person acts as an agent, representative, employee or servant, or in any other capacity at the order, request or under the foreign principal's direction or control. It is sufficient if the person agrees, consents, assumes or purports to act as, or who is or holds himself out to be, whether or not pursuant to contractual relationship, an agent of a foreign principal. The triggering activity is that the agent, directly or through any other person in the United States, 1. Engages in political activities for or in the interests of the foreign principal, which includes attempts to influence federal officials or the public. 2. Acts as public relations counsel, publicity agent, information service, employee or political consultant for or in the interests of such foreign principal. 3. Solicits, collects, disburses or dispenses contributions, loans, money or any things of value for or in the interest of such foreign principal. Or 4. Represents the interests of such foreign principal before any federal agency or official. It is a crime to engage in a willful violation of any provision of the Act or any regulation thereunder. It is also a crime willfully to make false statements or omissions of material facts in FARA registration statements or supplements. Most violations have a maximum penalty of 5 years of imprisonment and a $10,000 fine. So that's the legislation, the law. The application. The investigation uncovered extensive evidence that Paul Manafort's and Richard Gates' pre-campaign work for the government of Ukraine violated FARA. Manafort and Gates were charged for that conduct and admitted to it when they pleaded guilty to superseding criminal information in the District of Columbia prosecution. The evidence underlying those charges is not addressed in this report because it was discussed in public court documents in a separate prosecution memorandum submitted to the Acting Attorney General before the original indictment of that case. In addition, the investigation produced evidence of FARA violations involving Michael Flynn. Those potential violations, however, concerned a country other than Russia, i.e. Turkey, and were resolved when Flynn admitted to the underlying facts in the statement of offence that accompanied his guilty plea to a false statements charge. The investigation did not, however, yield evidence sufficient to sustain any charge that any individual affiliated with the Trump campaign acted as an agent of a foreign principal within the meaning of FARA or in terms of Section 951, subject to the direction or control of the government of Russia or any official thereof. In particular, the office did not find evidence likely to prove beyond a reasonable doubt that campaign officials such as Paul Manafort, George Papadopoulos and Carter Page acted as agents of the Russian government or at its direction, control or request during the relevant period. It's a redaction for a sentence after that. As a result, the office did not charge, redaction, any other Trump campaign official with violating FARA or Section 951 or attempting or conspiring to do so based on contacts with the Russian government or a Russian principal. Finally, the office investigated whether one of the above campaign advisors, George Papadopoulos, acted as an agent of or at the direction and control of the government of Israel. While the investigation revealed significant ties between Papadopoulos and Israel, and search warrants were obtained in part on that basis, the office ultimately determined that the evidence was not sufficient to obtain and sustain a conviction under FARA or Section 951. Campaign finance. Several areas of the office's investigation involved efforts or offers by foreign nationals to provide negative information about candidate Clinton to the Trump campaign, or to distribute that information to the public to the anticipated benefit of the campaign. As explained below, the office considered whether two of these efforts in particular, the June 9, 2016 meeting at Trump Tower, constituted prosecutable violations of the campaign laws. The office determined that the evidence was not sufficient to charge either incident in a criminal violation. That second incident was covered by a redaction there. Overview of governing law. The United States has a compelling interest in limiting the participation of foreign activities in activities of democratic self-government, and in thereby preventing foreign influence over the US political process. Blumen versus FEC. To that end, federal campaign finance law broadly prohibits foreign nationals from making contributions, donations, expenditures, or other disbursements in connection with federal, state, or local candidate elections, and prohibits anyone from soliciting, accepting, or receiving such contributions or donations. As relevant here, foreign nationals may not make, and no one may solicit, accept, or receive from them a contribution or donation of money or other thing of value, or an express or implied promise to make a contribution or donation in connection with a federal, state, or a local election. The term contribution, which is used throughout the campaign finance law, includes any gift, subscription, loan, advance, deposit of money, or anything of value made by any person for the purpose of influencing an election for federal office. It excludes, among other things, the value of volunteer services. Foreign nationals are also barred from making an expenditure, independent expenditure, or disbursement from an electioneering communication. The term expenditure includes any purchase, payment, distribution, loan, advance, deposit, or gift of money or anything of value made by any person for the purpose of influencing any election for the federal office. It excludes, among other things, news stories and non-partisan get-out-the-vote activities. An independent expenditure is an expenditure expressly advocating the election or defeat of a clearly identified candidate and made independently of the campaign. An electioneering communication is a broadcast communication that refers to a clearly identified candidate for federal office and is made within specified time periods and targeted at the relevant electorate. The statute defines foreign national by reference to FARA and the Immigration Nationality Act with minor modification. That definition yields 5 sometimes overlapping categories of foreign nationals, which include all of the individuals and entities relevant for the present purposes, namely foreign governments and political parties, individuals outside of the US who are not legal permanent residents, and certain non-US entities located outside of the US. A knowing and willful violation involving an aggregate of $25,000 or more in a calendar year is a felony. So the application to the June 9 Trump Tower meeting. The office considered whether to charge Trump campaign officials with crimes in connection with the June 9 meeting described in Volume 1, Section 4. The office concluded that in light of the government's substantial burden of proof on issues of intent, knowing and willful, and the difficulty of establishing the value of the offered information, criminal charges would not meet the Justice Manual standard that the admissible evidence will probably be sufficient to obtain and sustain a conviction. In brief, the key facts are that on June 3, 2016, Robert Goldstone emailed Donald Trump Jr. to pass along from Emin and Aras Agalarov an offer from Russia's Crown Prosecutor to the Trump campaign of official documents and information that would incriminate Hillary and her dealings with Russia and would be very useful to Trump Jr.'s father. The email described this as very high level and sensitive information that is part of Russia and its government support to Mr. Trump, helped along by Aras and Emin. Trump Jr. responded, "If it's what you say, I love it, especially later in the summer." Trump Jr. and Emin Agalarov had follow-up conversations and within days scheduled a meeting with Russian representatives that was attended by Trump Jr., Manafort and Kushner. The communication setting up the meeting and attendance by high-level campaign representatives support an inference that the campaign anticipated receiving derogatory documents and information from official Russian sources that could assist candidate Trump's electoral prospects. This series of events could implicate the federal election law ban on contributions and donations by foreign nationals. Specifically, Goldstone passed along an offer purportedly from a Russian government official to provide official documents and information to the Trump campaign for the purposes of influencing the presidential election. Trump Jr. appears to have accepted that offer and to have arranged a meeting to receive those materials. Documentary evidence in the form of email chains supports the inference that Kushner and Manafort were aware of that purpose and attended the June 9 meeting anticipating the receipt of helpful information to the campaign from Russian sources. The office considered whether this evidence would establish a conspiracy to violate the foreign contributions ban in violation of 18 U.S.C. 371, the solicitation of an illegal foreign source contribution, or the acceptance or receipt of an express or implied promise to make a foreign source contribution, both in violation of 52 U.S.C. 30121. These are reasonable arguments that the offered information would constitute. There are reasonable arguments that the offered information would constitute a thing of value within the meaning of these provisions, but the office determined that the government would not be likely to obtain and sustain a conviction for two other reasons. First, the office did not obtain admissible evidence likely to meet the government's burden of proof beyond a reasonable doubt that these individuals acted willfully, i.e. the general knowledge of the illegality of their conduct, and second, the government would likely encounter difficulty in proving beyond a reasonable doubt that the value of the promised information exceeded the threshold of a criminal violation. See 52 U.S.C. Thing of value element. A threshold legal question is whether providing a campaign documents and information of the type involved here would constitute a prohibited campaign contribution. The foreign contribution ban is not limited to contributions of money. It expressly prohibits a contribution or donation of money or other thing of value. And the term contribution is defined throughout the campaign finance laws as to include any gift, subscription, loan, advance, or deposit of money or anything of value. The phrases thing of value and anything of value are broad and inclusive enough to encompass at least some forms of valuable information. Throughout the United States Code, these phrases serve as terms of art that are construed broadly. Some legal references here. Thing of value concludes both tangibles and intangibles. A whole lot of case law cited there. And in the public corruption context, thing of value is defined broadly to include the value which the defendant subjectively attaches to the items received. Federal Election Commission FEC regulations recognise the value to a campaign of at least some forms of information, stating that the term anything of value includes the provision of any goods or services without charge, such as membership lists and mailing lists. The FEC has concluded that the phrase includes a state-by-state list of activists. Likewise, polling data provided to a campaign constitutes a contribution, reference to a whole lot of case law. And in the specific context of the foreign contributions ban, the FEC has concluded that election materials used in previous Canadian campaigns, including flyers, advertisements, door hangers, trifold signs, and other printed material, constitute anything of value, even though the value of those materials may be nominal or difficult to ascertain. These authorities would support the view that candidate-related opposition research given to a campaign for the purpose of influencing election will constitute a contribution to which the foreign source ban could apply. A campaign can be assisted not only by the provision of funds, but also by the provision of derogatory information about an opponent. Political campaigns frequently conduct and pay for opposition research. A foreign entity that engaged in such research and provided provided resulting information to a campaign could exert a greater effect on an election and a greater tendency to ingratiate the donor to the candidate than a gift of money or tangible things of value. At the same time, no judicial decision has treated the voluntary provision of uncompensated opposition research or similar information as a thing of value that could amount to a contribution under campaign finance law. Such an interpretation could have implications beyond the foreign source ban. See 52 USC, imposing monetary limits on campaign contributions, and raise First Amendment questions. Those questions could be especially difficult where the information consisted simply of the recounting of historically accurate facts. It is uncertain how courts would resolve those issues. Willfulness. Even assuming that the promised documents and information that would incriminate Hillary constitute a thing of value under campaign finance law, the government would encounter other challenges in seeking to obtain and sustain a conviction. Most significantly, the government has not obtained admissible evidence that is likely to establish the scienter requirement beyond a reasonable doubt. To prove that a defendant acted knowingly and willfully, the government would have to show that the defendant had general knowledge that his conduct was unlawful. Some case law references there. This standard creates an elevated center. I don't know that word. Element requiring at the very least the application of the law of the facts in question to be fairly clear. When there is a substantial doubt concerning whether the law applies to the facts of a particular matter, the offender is more likely to have an intent defence. On the facts here, the government would unlikely be able to prove beyond a reasonable doubt that the June 9 meeting participants had general knowledge that their conduct was unlawful. The investigation has not developed evidence that the participants in the meeting were familiar with the foreign contribution ban or the application of federal law to the relevant factual context. The government does not have strong evidence of surreptitious behaviour or efforts at concealment at the time of the June 9 meeting. While the government has evidence of later efforts to prevent disclosure of the June 9 meeting, that could circumstantially provide support for a showing of scienter, that concealment occurred more than a year later, involved individuals who did not attend the June 9 meeting, and may reflect an intention to avoid political consequences rather than any prior knowledge of illegality. Additionally, in light of the unresolved legal questions about whether giving documents and information in the sort offered here constitutes a campaign contribution, Trump Jr. could mount a factual defence that he did not believe his response to the offer and the June 9 meeting itself violated the law. Given his less direct involvement in arranging the June 9 meeting, Kushner could likely mount a similar defence, and while Manafort is experienced with political campaigns, the office has not developed evidence showing that he had relevant knowledge of these legal issues. Difficulties in valuing promised information. The office would also encounter difficulty proving beyond a reasonable doubt that the value of the promised documents and information exceeds the $2,000 threshold for a criminal violation as well as the $25,000 threshold for felony punishment. The type of evidence commonly used to establish value of non-monetary contributions, such as pricing the contribution on a commercial market or determining the upstream acquisition cost or the cost of distribution, would likely be unavailable or ineffective in this factual setting. Although damaging opposition research is surely available to a campaign, it appears that the information ultimately delivered in the meeting was not valuable. And while value in a conspiracy may well be measured by what the participants expected to receive at the time of the agreement, Goldstone's description of the offered material here was quite general. His suggestion of the information's value, i.e. that it would incriminate Hillary and would be very useful to Trump Jr.'s father, was non-specific and may have been understood as being of uncertain worth or reliability, given Goldstone's lack of direct access to the original source. The uncertainty over what would be delivered would be reflected in Trump Jr.'s response, "If it's what you say, I love it," emphasis added. Accordingly, taking into account the high burden to establish a culpable mental state in a campaign finance prosecution, and the difficulty in establishing the required valuation, the office decided not to pursue criminal campaign finance charges against Trump Jr. or other campaign officials for the events culminating in the June 9 meeting. Application to a redaction, and we have a full redaction for this whole section, 1.5 pages long. We don't know what that section was about. Willfulness. As discussed, to establish a criminal campaign finance violation, the government must prove that the defendant acted knowingly and willfully. That standard requires proof that the defendant knew generally that his conduct was unlawful. Given the uncertainties noted above, the willfulness requirement would pose a substantial barrier. So we're talking about an unknown situation there. We don't know what they're actually talking about there. Finally, the First Amendment would pose constraints to a prosecution. Further redaction here, analysis, harm to ongoing matter. Okay. Further redaction, false statements and obstruction of the investigation. The office determined that certain individuals associated with the campaign lied to investigators about campaign contacts with Russia and have taken other actions to interfere with the investigation. As explained below, the office therefore charged some US persons connected to the campaign with false statements and obstruction offences. False statements. The principal federal statute criminalising false statements to government investigators is 18 U.S.C. 1001. As relevant here, under Section 1001, it is a crime to knowingly and willfully make any materially false, fictitious or fraudulent statement or representation in any matter within the jurisdiction of the executive branch of the government. An FBI investigation is a matter within the executive branch's jurisdiction. The statute also applies to a subset of legislative branch actions, administrative matters and investigations or reviews conducted by congressional committee or subcommittee. Some case law references there. Whether the statement was made to law enforcement or congressional investigators, the government must prove beyond a reasonable doubt that the same basic non-jurisdictional elements, the statement was false, fictitious or fraudulent, the defendant knew that it was false and that it was unlawful to make a false statement, and the false statement was material. What have we got here? See also the Ninth Circuit patent instruction explaining the Section 1001 jury instruction was modified to, in light of the Department of Justice position that the phrase knowingly and willfully in the statute requires the defendant's knowledge that his or her conduct was unlawful. In the DC Circuit, the government must prove that the statement was actually false. A statement that is misleading but literally true does not satisfy that section. For that false statement to qualify as material, it must have a natural tendency to influence or be capable of influencing a discrete decision or any other function of the agency to which it is addressed. Perjury. Under federal perjury statutes, it is a crime for a witness to testifying under oath before a grand jury to knowingly make any false material declaration. The government must prove 4 elements beyond a reasonable doubt to obtain a conviction under Section 1623. The defendant testified under oath before a federal grand jury. The defendant's testimony was false in one or more aspects. False testimony concerned matters that were material to the grand jury investigation, and the false testimony was knowingly given. The general perjury statute, 18 U.S.C. 1621, also applies to grand jury testimony. It has similar elements, except that it requires that the witness have acted willfully and that the government satisfy strict common law requirements for establishing falsity. Obstruction of justice. 3 basic elements are common to the obstruction statutes pertinent to this officer's charging decisions. An obstructive act, some form of nexus between the obstructive act and an official proceeding, and criminal, i.e. corrupt intent. A detailed discussion of those elements in the law governing obstruction of justice more generally is included in Volume 2 of the report. Okay, after all that, application to certain individuals. We can go through each individual one by one here. First one's George Papadopoulos. Investigators approached Papadopoulos for an interview based on his role as a foreign policy advisor to the Trump campaign and his suggestion to a foreign government representative that Russia had indicated that it could assist the campaign through the anonymous release of information damaging to candidate Clinton. January 27, 2017, Papadopoulos agreed to be interviewed by FBI agents, who informed him that the interview was part of the investigation into potential Russian government interference in the 2016 presidential election. During the interview, Papadopoulos lied about the timing, extent and nature of his communication with Joseph Mifsud, Olga Polyamskaya and Ivan Timofeyev. With respect to timing, Papadopoulos acknowledged that he had met with Mifsud, and Mifsud told him the Russians had dirt on Clinton in the form of thousands of emails, but Papadopoulos stated multiple times that those communications occurred before he joined the Trump campaign, that it was a very strange coincidence to be told of the dirt before he started working for the campaign. This account was false. Papadopoulos met Mifsud for the first time approximately March 14, 2016, after Papadopoulos had already learned that he would be a foreign policy advisor for the campaign. Mifsud showed interest in Papadopoulos only after learning of his role in the campaign, and Mifsud told Papadopoulos about the Russians possessing dirt on candidate Clinton in late 2016, more than a month after Papadopoulos had joined the campaign and had been publicly announced by candidate Trump. Papadopoulos also made false statements in an effort to minimise the extent and importance of his communications with Mifsud. For example, Papadopoulos stated that Mifsud's a nothing and he thought Mifsud was just a guy talking up connections or something, that he believed Mifsud was BSing, to be completely honest with you. In fact, however, Papadopoulos understood Mifsud to have substantial connections to high-level Russian government officials and that Mifsud spoke with some of those officials in Moscow before telling Papadopoulos about the dirt. Papadopoulos also engaged in extensive communications over a period of months with Mifsud about foreign policy issues for the campaign, including efforts to arrange a history-making meeting between the campaign and Russian government officials. In addition, Papadopoulos failed to inform investigators that Mifsud had introduced him to Timofeyev, the Russian national who Papadopoulos understood to be connected to the Russian Ministry of Foreign Affairs, despite being asked if he had met with Russian nationals or anyone with a Russian accent during the campaign. Papadopoulos' statement of offence. Papadopoulos also falsely claimed that he met Polyamskaya before he joined the campaign, and falsely told the FBI that he had no relationship at all with her. He stated that the extent of their communications was her sending emails, just "Hi, how are you?" and that's it. In truth, however, Papadopoulos met Polyamskaya on March 24, 2016, after he joined the campaign. He believed that she had connections to high-level Russian government officials and could help him arrange a potential foreign policy trip to Russia. During the campaign, he emailed and spoke with her over Skype on numerous occasions about the potential foreign policy trip to Russia. Papadopoulos' false statements in January 2017 impeded the FBI's investigations into Russian interference in the 2016 presidential election. Most immediately, those statements hindered investigators' ability to effectively question Mifsud when he was interviewed in the lobby of a Washington, D.C. hotel on February 10, 2017. During that interview, Mifsud admitted to knowing Papadopoulos and to having introduced him to Polyamskaya and Timofeyev, but Mifsud denied that he had advanced knowledge that Russia was in possession of emails damaging to candidate Clinton, stating that he and Papadopoulos had discussed cybersecurity and hacking as a larger issue and that Papadopoulos must have misunderstood their conversation. Mifsud also falsely stated that he had not seen Papadopoulos since the meeting at which Mifsud introduced him to Polyamskaya, even though emails, text messages and other information show that Mifsud met with Papadopoulos on at least two other occasions, April 12 and April 26, 2016. In addition, Mifsud admitted that he had drafted or edited the follow-up message from Polyamskaya sent to Papadopoulos following the initial meeting, and that, as reflected in the language in the email chain, "Baby, thank you," Mifsud may have been involved in a personal relationship with Polyamskaya at the time. The false information and omissions in Papadopoulos' January 2017 interview undermined investigators' ability to challenge Mifsud when he made these inaccurate statements. Given the seriousness of the lies and omissions and their effects on the FBI investigations, the office charged Papadopoulos with making false statements to the FBI in violation of 18 U.S.C. 1001. Papadopoulos, on October 7, 2017, pleaded guilty to that charge pursuant to a plea agreement. On September 7, 2018, he was sentenced to 14 days of imprisonment, $9,500 fine, $200 hours of community service. So we're talking about the application to individuals, and the next individual is completely redacted, so I don't know who that is. Maybe that's Paul Manafort, don't know. Next one is Michael Flynn. Michael Flynn agreed to be interviewed by the FBI on January 24, 2017, 4 days after he officially assumed his duties as National Security Advisor to the President. During the interview, Flynn made several false statements pertaining to his communications with the Russian ambassador. First, Flynn made 2 false statements about his conversations with Ambassador Kislyak in late December 2016, at a time when the United States had imposed sanctions on Russia for interfering with the 2016 presidential election, and Russia was considering its response. See Flynn's statement of offence. Flynn told the agents that he did not ask Kislyak to refrain from escalating the situation in response to the United States' imposition of sanctions. That statement was false. On December 29, 2016, Flynn called Kislyak to request Russian restraint. Flynn made the call immediately after speaking to a senior transition team official, KT McFarlane, about what to communicate to Kislyak. Flynn then spoke with McFarlane again after the Kislyak call to report on the substance of their conversation. Flynn had falsely told the FBI he did not remember a follow-up conversation in which Kislyak stated that Russia had chosen to moderate its response to the US sanctions as a result of Flynn's request. On December 31, 2016, Flynn in fact had such a conversation with Kislyak, and again spoke with McFarlane within hours of the call to relay the substance of the conversation with Kislyak. Second, Flynn made false statements about calls he had previously made to representatives of Russia and other countries regarding a resolution submitted by Egypt to the United Nations Security Council on December 21, 2016. Specifically, Flynn stated that he only asked the countries' positions on how they would vote on the resolution, and he did not request that any of the countries take any particular action on the resolution. That statement was false. On December 22, 2016, Flynn called Kislyak, informed him of the incoming Trump administration's opposition to the resolution, and requested that Russia vote against or delay the resolution. Flynn also falsely stated Kislyak never described Russia's response to his December 22 request regarding the resolution. Kislyak, in fact, told Flynn in a conversation on December 23, 2016, that Russia would not vote against the resolution if it came to a vote. Flynn made these false statements to the FBI at a time when he was serving as National Security Advisor, and when the FBI had an open investigation into Russian interference in the 2016 presidential election, including the nature of any links between the Trump campaign and Russia. Flynn's false statements and omissions, impeded and otherwise, had a material impact on that ongoing investigation. They also came shortly before Flynn made separate submissions to the Department of Justice pursuant to FARA that also contained materially false statements and omissions. Based on the totality of their conduct, the office decided to charge Flynn with making false statements to the FBI in violation of 18 U.S.C. 1001. On December 1, 2017, pursuant to a plea agreement, Flynn pleaded guilty to that charge and also admitted his false statements to the department in his FARA filing. Flynn is awaiting sentencing. Next individual, Michael Cohen. Michael Cohen was the Executive Vice President and Special Counsel to the Trump Organization when Trump was President of the Trump Organization. From the fall of 2015 through approximately June 16, Cohen was involved in a project to build a Trump-branded tower and adjoining development in Moscow. The project was known as Trump Tower Moscow. 2017, Cohen was called to testify before the House Permanent Select Committee on Intelligence and the Senate Select Committee on Intelligence, both of which were investigating Russian interference in the 2016 presidential election and possible links between Russia and the presidential campaigns. In late August 2017, in advance of his testimony, Cohen caused a 2-page statement to be sent to the 2 committees addressing Trump Tower Moscow. The letter contained 3 representations relevant here. First, Cohen stated that the Trump Tower project had ended in January 2016, that he had briefed candidate Trump on the project only 3 times before making the unilateral decision to terminate it. Second, Cohen represented that he never agreed to travel to Russia in connection with the project and never considered asking Trump to travel for the project. Third, Cohen stated that he did not recall any Russian government contact about the project, including any response to an email that he had sent to Russia government email account. Cohen later asked that his 2-page statement be incorporated into his testimony transcript before the Senate committee, and he ultimately gave testimony to the Senate committee that was consistent with that statement. Each of the foregoing representation in Cohen's 2-page statement was false and misleading. Consideration of the project had extended through approximately June 2016 and included more than 3 progress reports from Cohen to Trump. Cohen had discussed with Felix Sater his own travel to Russia as part of the project, and he inquired about the possibility of Trump travelling there, both with the candidate himself and with senior campaign official Corey Lewandowski. Cohen did recall that he had received a response to the email that he sent to Russian government spokesman Dmitry Peskov, in particular that he received an email reply and had a follow-up phone conversation with an English-speaking assistant to Peskov in mid-January 2016. Cohen knew the statements in the letter to be false at the time and admitted that he made them in an effort to, 1, minimise links between the project and Trump, who by this time was president, and 2, to give false impression that the project had ended before the first vote in the Republican Party primary process in the hopes of limiting the ongoing Russian investigations. Given the nature of the false statements and the fact that he repeated them during his initial interview with the office, we charged Cohen with violating Section 1001. November 29, 2018, Cohen pleaded guilty pursuant to a plea agreement to a single count information charging him with making false statements in a matter within the jurisdiction of the legislation branch in violation of 18 U.S.C. 1001. The case was transferred to the district judge presiding over the separate prosecution of Cohen pursued by the Southern District of New York after referral from our office. On December 7, 2018, this office submitted a letter to that judge recommending that Cohen's cooperation with our investigation be taken into account in sentencing Cohen on both the false statements charge and the offences in the Southern District prosecution. On December 12, 2018, the judge sentenced Cohen to 2 months of imprisonment on the false statements account to run concurrently with a 36-month sentence imposed on other counts. The next individual's name is redacted, and all of the information about that individual is redacted. The next individual following that is Jeff Sessions. As set forth in Volume 1, Section 4, the investigation established that while a U.S. Senator and Trump campaign advisor, former Attorney General Jeff Sessions interacted with Russian Ambassador Kislyak during the week of the Republican National Convention in July 2016 and again at a meeting in Sessions' Senate office in September 2016. The investigation also established that Sessions and Kislyak both attended a reception held before Trump's foreign policy speech at the Mayflower Hotel in Washington, D.C. in April 2016, and that it is possible that they met briefly at the reception. The office considered whether, in light of these interactions, Sessions committed perjury before or made false statements to Congress in connection with his confirmation as Attorney General. In January 2017, testimony during his confirmation hearing, Sessions stated in response to a question about Trump campaign communication with the Russian government that he had been called a surrogate at a time or two in that campaign, and I did not have communication with the Russians. In written responses submitted on January 17, 2017, Sessions answered no to a question asking whether he had been in contact with anyone connected to any part of the Russian government about the 2016 election, either before or after election day. And in a March 2017 supplement to his testimony, Sessions identified 2 of the campaign period contacts with Ambassador Kislyak noted above, which had been reported in the media following a 2017 confirmation hearing. Sessions stated in the supplemental response that he did not recall any discussions with the Russian ambassador or any other representatives of the Russian government regarding the political campaign on those occasions or any other occasion. Although the investigation established that Sessions interacted with Kislyak on the occasions described above and that Kislyak mentioned the presidential campaign on at least one occasion, the evidence is not sufficient to prove that Sessions gave knowingly false answers to Russia-related questions in light of the wording and context of those questions. With respect to Sessions' statements, he did not recall any discussions with the Russian ambassador regarding the political campaign. He had not been in contact with any Russian official about the 2016 election. The evidence concerning the nature of Sessions' interaction with Kislyak makes it plausible that Sessions did not recall discussing the campaign with Kislyak at the time of his statements. Similarly, while Sessions stated in his January 2017 oral testimony that he did not have communications with the Russians, he did so in response to a question that had linked such communications to an alleged continuing exchange of information between the Trump campaign and Russian government intermediaries. Sessions later explained to the Senate and to the office that he understood the question as narrowly calling for disclosure of interactions with Russians that involved the exchange of campaign information, as distinguished from more routine contacts with Russian nationals. Given the context in which the question was asked, that understanding is plausible. Accordingly, the office concluded that the evidence was insufficient to prove that Sessions was willfully untruthful in his answers and thus insufficient to obtain or sustain a conviction for perjury or false statements. Consistent with the principles of federal prosecution, the office therefore determined not to pursue charges against Sessions, and he informed his counsel of that decision in March 2018. Others interviewed during the investigation. The office considered whether, during the course of the investigation, other individuals interviewed either omitted material information or provided information determined to be false. Applying the principles of federal prosecution, the office did not seek criminal charges against any individuals other than those listed above. In some instances, the decision was due to evidentiary hurdles to proving falsity. In others, the office determined that the witness ultimately provided truthful information and that considerations of culpability, deterrence and resource preservation weighed against prosecution. We've got the rest of the page is fully redacted, and that is the end of volume 1. That's quite an effort. End of page 199. Volume 1 is over. Tomorrow we start looking at volume 2.